Good morning, everybody. My name is Mike Rafi. I am a personal injury lawyer here in Atlanta. I appreciate you joining the webinar, whether you're watching live, really appreciate it. If you're watching on YouTube later or somewhere else, wherever we end up putting this video. I'm really excited about today's webinar because we get to tell four war stories about our cases and how we did it, how we won, what we thought about in our thought process. I thought this would be really helpful today to run through a couple of real cases, the actual issues that we covered, that we faced, and how we overcame them. And like I said, the thought process is what I really want to focus on today. As a marketing tip, as an aside, you have to have some good war stories. Everywhere you go, when the world turns back on, when you go out and you meet people and you see people, or even when you have calls with somebody today or email with them, you're going to eventually get asked like, hey, how's work going? And in this chat this morning, a bunch of people, thank you, asked me, how's everything going? What's new? And I gave some bad answers. I just said, oh, fine, I'm doing great. Especially in person, you need to have a war story. You need to have something that says, you know, here's what I'm doing. I'm excited about it. Here's how it's going to work out, and kind of sells yourself. So Lewis Cohen actually taught me this a while ago. He said, every time someone asks what you're working on, you know, what are you working on? What's going on? You need to have a prepared story to say, and you need to make it exciting, and it needs to be real. It needs to be true. But the worst, no offense to anybody out there, I've been this person. The worst marketing conversation, the worst networking conversation starts like this. Hey, nice to meet you. Tell me about yourself. What are you working on? Oh, got some cases. Things are going good. Yeah. You have any interesting cases? No. Same old, same old. You need to have some good war stories. So these are four of our war stories. Then I'm going to have all of my lawyers come on, and we're all going to talk about four of these cases. They're all very different. We tried to pick four cases that all touch on different areas. And we tried to pick some ones that we thought were exciting. So that's the process here. I'm going to call up Arthur York, and I'm going to get him to join us right now. Here's the man. Arthur, get some video, get some unmuting, and let's have you join. There he is.
I'm here. Hey, guys.
Arthur, can we hear you?
Yeah. Can you hear me?
All right. Perfect. So when Arthur's not beating people up in a mixed martial arts ring, he's usually beating them up in discovery or in motions or whatever he's got going on. Depots, although not physically. Arthur and I worked on a case. It was a motorcycle crash case. And it was an interesting case because we had a video. So we're going to play the video. It is choppy. The reason it's choppy is because at the end of the video, our client's going to get hit by someone, and the GoPro camera that's on the top of his head, surprisingly, doesn't capture a great recording when you get hit at however fast he was going. We can talk about that in a few minutes. But I assume most people on this webinar are familiar with Peachtree. Arthur, you want to tell everybody where this happened?
Yeah. So our client, like Mike said, was on a motorcycle, and he was actually driving, would have been south on Peachtree in front of the stretch where, I don't know if you're familiar with it, where Oglethorpe University is. There's a Costco there, but it's in Brookhaven. And he's going, you know, like Mike said, the video shows about a minute, and he's headed sort of towards the Phipps Plaza area from the Brookhaven area.
Yeah, he's about to come up on, what is that? The MARTA station on the left there.
Right.
And he's got a GoPro camera on his helmet. Why, if you're going to break the law, why would you wear a GoPro camera? It's beyond me. But what we're going to do is I can't stop the video just because it is a bad recording. But I'm going to play it in full twice. The first time we'll let it run. The second time, Arthur, if you want to narrate, you know what I'm doing when I say this and what he's doing. All right, so let me show you all the video here. Share this screen. Bear with me, folks. Here we go. I love how it starts. Actually, that's a shorter version. Did I click the wrong one? My fault. No, this is the version we're using, Arthur. I cut it so it's not as choppy. All right, so do you want to tell everybody what's going on in the minute before this video, and I'll keep playing this and let everybody get a good idea of it?
Yeah, so, you know, he's driving down Peachtree on a motorcycle, and you can kind of see here where he goes around the double line. This is kind of what he was doing the whole time. I mean, it's the exact kind of thing that you see somebody on a motorcycle driving like this, and in your mind, you're saying, man, that guy's a maniac. We've all seen it on the roads. I'm not saying that everybody who owns a motorcycle drives like this, but some of them do. And our client happened to be one of them that day. So for about 55 seconds, he's driving down Peachtree. He's flying by everybody. He actually at one point looks down, or 2 points, looks down at his speedometer. The camera actually can see the speed. At one point, it's 65 miles an hour. Now this is
rush hour. This is rush hour on Peachtree.
Right, morning rush hour. He's headed to work at Mercedes-Benz Stadium. So this is kind of just a snapshot of what he was doing. But in truth, I mean, he was doing this all the way down, weaving in and out, passing people, crossing over lines he wasn't supposed to cross over. And then this is the culmination of it here at the end where he gets hit in a nasty crash for sure.
So one thing we tried to do, I mean, you said it was 55 seconds, and he is going on the wrong side of the road. He's weaving left. He's weaving right. I mean, he's weaving everywhere.
Right.
One thing we tried to do was limit the use of the video. You want to tell everybody what we did? I'm going to show, before you do, I'll show the part. So we go to the judge and we say, Judge, we only think that this one part should be played. And I'll show you all that part, and you can guess what that part was.
Right.
All right.
So yeah, we actually filed a motion for in limine before discovery ended, and it was a motion for summary judgment also, a plaintiff's motion for summary judgment. On the idea that, hey, look, the 4 seconds before this crash occurred, leading right up to it, he's in his own lane. I mean, he is in a turning lane, and he testified he was going to make that next left turn. There's no way for them to refute that that's what he was going to do. It's in his mind. That's what he was going to do.
So I stopped it right at the beginning of the video. And as y'all can see, maybe unsurprisingly, the reason that we wanted to play this video is because it starts with him in the correct lane. He's in the right lane. And it goes all the way through the crash. Now, one thing we thought was interesting was, and Arthur made some great illustrations and diagrams of how we showed this, but up until about this point, he can't see her and she can't see him. So our argument was nothing before this moment mattered.
Right.
Nothing mattered. Now, Arthur, did we win this motion, although we spent an incredible amount of time?
No, I'll tell you what happened. So we get, and it's a great judge we had in this case, but we got there, and he said, well, let me take, hear the arguments. Let me take a look at this video. And when he said that, I kind of said, oh, crap. He hadn't seen it yet. And if for the first time he's going to see the video, including the entire video and this clip, and we could kind of see him looking at it on his screen from where we were. And I just kind of nudged Mike and said, we ain't winning this one. And a reasonable thing for the judge to deny, but we felt that there was a chance that we might win, and it was such an important thing to try that we had to try it. We had to make an effort on that motion. So we lost, but.
And one other argument we made during this whole thing was that if our guy was going 80 miles an hour after, or like they claimed, or like the video showed, whatever it was, 60, 70, 80 miles an hour,
right?
55 seconds was so far, so far away from the crash that we said it didn't matter. I actually thought, I really liked the argument. I liked it more than Arthur did. I think he was more realistic with us. But watching the judge's face on the bench while he watched it, he goes like this. And then starts laughing. And I mean, at that point, but we made them work for it. I mean, we did it, like Arthur said, a motion for summary judgment, because we said for the last 4 seconds, our guy is doing absolutely nothing wrong. And it also made them put their cards on the table. So one thing they did, Arthur, was they hired an expert. Tell everybody about the expert that we got them to at least hire or at least disclose because of our motion for summary judgment, because they had to defend themselves.
Right. So after we had this hearing, we were going on this this motion and everything. They actually disclose an expert, an accident reconstructionist, who I'm sure a lot of folks on this who are watching now would be familiar with. He's a kind of a frequent flyer.
I'm going to use his name. You can say it. I'm going to show the depot.
Yeah, sure. So it's Anastasios Soumanis. He's a State Farm uses him a lot. He's with, it's not Rimkiss. I can't remember who it is. Maybe it is Rimkiss. Yeah. Anyway, so they disclose him, and Mike goes and takes his deposition, and the guy says, yes, I did my calculations. Okay, what did you base on this, that's that? How'd you do it? I did this, that. And what was your conclusion? That he was, well, I concluded that in the moments preceding the crash, your client was traveling 44.6 miles per hour. Well, we had already gone and gotten the city of Brookhaven certified resolution showing exactly what the speed limit was on that stretch of road, and it was 45 miles an hour. So their expert testified that our client was actually going the speed limit when the crash occurred. So now
at the time of impact, because he is hard braking.
Right. So now he is legally in his lane for at least 4 seconds before the crash. He's going the speed limit, so he's not doing anything wrong. And we felt really good about it then. Another really interesting thing that we did, that Mike did in that deposition, was we did it he kind of did it in 2 depositions.
Let me pull this up.
Sure.
I know where you're going. Let me see. I'm going to show you all the deposition. It's not exciting, but at least I'll show you one thing. So Arthur was saying about 2 parts. Arthur, what was the first part? So the
first part was kind of what you do a regular cross, crossing their expert, leading questions, getting everything you need. Well, after he got all that and we knew what his answers were, we thought, and Mike astutely so thought, well, hell, if they don't call him, he's really good for us. If they don't call him, we need to be able to call him ourselves. So why not just do now basically a direct of him, so they can't object to leading questions if they don't call him. So he just went back through, asked all the same questions, but as a direct. So now if they decided not to call him at trial, we basically had our own expert who we didn't have to pay for, who was going to testify that our client was going the speed limit.
Yeah. So a few things I want to circle back to is, first, the plaintiff's lawyers, we can be aggressive and we can be the aggressor in most issues, but it's pretty rare that we're the aggressor in summary judgment. We don't move for summary judgment a lot because there are fact issues. Here, I mean, we pretty much knew we were going to lose, but there was a small chance that we might win. It was a colorable argument. We had a viable argument. Reason we made the summary judgment motion was to see what their case was going to be, because nothing against State Farm, or maybe something against State Farm. We're not getting full discovery responses. We're not getting another side that's interested in the case and wants to move it. So as a result of our motion for summary judgment, we're expecting them to disclose an expert, and they do. So our mission was already accomplished. And when they disclose the expert, he says they're going under the speed limit. And that was his only opinion, which I thought was crazy. He also, I guess he had other opinions. At 100 feet, our guy was over the speed limit. At whatever feet it was over over the speed limit. And then by the moment of impact, he's barely under it. When you get an expert opinion like that, you got to look at what the opinion doesn't say. And what it didn't say was anything about perception reaction time. So I got the depot up, and you can see that I've got page 65 pulled up. So for 64 pages, I did a cross of the expert, including perception reaction time, including all the things that I wanted. And then in the middle of the depot, I remember I called Arthur and I was like, this guy's great. I think he's going to be our expert. We pretty much made him our expert. And what I have highlighted here on page 65 is in the middle of the depot, we took a break. On the previous page, we took a break. And then I said, I'm going to start over. So I started with it being a direct. Will you tell me your name? And I went through his qualifications. I think I qualified him as an expert. And then, what are they going to do? How are they going to object to their own expert? And then by the end, it ends with an opinion, a conclusion that we want. So what that does is it takes away the chance of them to say, oh, we're not going to call our expert. We've actually got an expert for free except to testify. And Arthur, tell everybody what the result of this case is. I mean, for background, there's $1 million policy in UM. The at-fault driver who hit him, the girl who pulled out, she paid her $50, so we're left with $950. And what do they do?
So let me just first quickly apologize. I've got a fire alarm in my home office here that won't stop beeping, and I've tried to fix it, but y'all bear with me. I appreciate that. So our client, first of all, just quick on damages, he had over $700,000 in medical bills. He had several surgeries, terrible injury, degloving injury of his right foot. They had to do a skin graft, all this stuff. So what we did was, after we had the testimony from Tsunamis and we had everything that we needed, we sent them basically a bad faith demand for the policy limits. They did not pay it. And then a couple months later, we sent another one.
Yeah, I think we sent 2 or 3 or 4. We just kept sending demands.
Right. So sent another one. They still didn't pay it. And then finally, as we got closer to trial, we filed our motions in limine, and we actually filed another motion in limine on the video issue again. Yeah. Why not? And several other things that we thought were strong. And finally, you just tell them how it resolved.
Yeah, they called us up and paid it. They gave in.
Yeah. As we got closer and closer to trial, finally, I think they took a long look at it and said, crap, we don't really have any defenses at this point, other than he is a bad driver, several moments before this happened.
Yeah. So I think the keys of this case was that we didn't sit on our hands. What we actively, even if we lost some of these issues, we actively pushed the case and we made them participate. We made them disclose their case theory. And then with the expert, being able to turn that expert, a lot of people say, oh, I turn the expert. My fear then, if I turn an expert, is, well, they're just not going to disclose. They're not going to call him. I want to turn that expert and make sure that I can call the expert if I really want to. So that's why we did the direct that same day so it really worked. All right, Arthur, awesome. We took a case where a guy was going on the wrong side of the road at freaking 80 miles an hour, weaving in and out of rush hour traffic. I don't think he did anything wrong with the crash, but he was acting like a complete asshole. So
Mike and I both used to be defense lawyers. If I was still a defense lawyer and somebody sent me a demand with that video, yeah. But that's why we had to do what we did.
All right. I'm kicking you out, and then we're going to get in our next victim. If I can figure out how to kick you out. There we go. Everybody say bye, Arthur. Bye, Arthur. All right, y'all. Hopefully that helped. So again, the takeaway I have is you can be offensive in your case. You can do things to make the other side participate. Even if you don't have a strong chance of winning, it's worth making arguments that will get you the information you need. We knew they had an expert. We wanted to know who it was, and we wanted to make them disclose the expert, as opposed to waiting months and months down the line because it's state court and there were no immediate deadlines. All right, so that was our first motorcycle case. Our next victim is Chris Stokes, who just cut his own hair. So I want y'all it's not bad. So I'm going to bring him on here. He's joining right now. Cut his own hair. I cut my back. Got a little high over here, but he cut his own hair. Let's see how he looks. Like a child. Like a child. Okay.
And I think it looks a lot like Mike's. So anything that he says against it, it kind of comes back on him.
Wow. Yeah. I mean, did you use a bowl? Like, did you just cut around it?
No. This is all pure talent and sleight of hand right here.
Okay. All right, Chris, we're going to talk about a case. It was some of y'all, I mean, I read the Daily Report all the time. This made its way in there. It was a case where our client was a pedestrian. He was hit by a car. Stokes, you want to walk everybody through the background here and tell everybody what happened?
Yeah, so we got this case pretty early on, actually. We learned about our client through our client's wife while he was still in the hospital. And it was only, I don't know, Mike, 4 or 5 days after he was hit.
He was in Grady ICU.
Right. He was in Grady ICU, and at that point, he was not fully conscious. He was being monitored constantly, CT scans on his brain all the time. And so we had to put the pieces together to try and figure out what exactly happened. Because oftentimes with orthopedic injuries, like a leg or something like that, or in a shooting case, which we have a lot of, we can ask the person who was injured, right? In this instance, it was almost similar to a wrongful death case in that the person that we were trying to speak with about what happened was unconscious. And what we would later learn is that he wouldn't remember the incident at all.
Or remember things that we knew weren't right.
Right, right. So what we pieced together, and then what we did with it, is we pieced together that our client had gone on a walk with his dog at about 10 in the morning or so in his neighborhood. And while he was walking, someone with a driveway that went down towards the road kind of whipped out of their driveway and backed into him, hit his shoulder, tossed him across the road, and then he hit his head on the pavement.
I'm going to show some photos we have in our demand. I imagine most people on here are not squeamish, and these aren't absurdly terrible. But, you know, there is blood. There's a bad injury, just as a warning to y'all. So let me share this with you. So this is post, the officer had a body cam. So this is post crash. Stokes, can you see this? Can everybody see this?
Yep.
All right. So this is post crash. This is our defendant driver. This is our client. You can see the blood there. The officer, well, actually that's the lady who ran over. That's the neighbor, we think, right?
Yes. Mm-hmm.
Yeah. So what happened? So he gets hit, and actually y'all can see right here. That's the indent of his body print. I mean, that is him in the car. So we don't know how fast this guy was going down the hill of his driveway, but he was motoring. Stokes, why don't you tell everybody what happened after the impact?
Yeah. So what we needed to do is, because we had this case so early, we try and go investigate these types of cases sooner rather than later. Because whether it's a shooting, whether it's a trucking case where there could be debris on the roadway, or whether it's a case like this, the evidence goes away, right? So we didn't have the body cam, as I'm sure any of you who have gotten body cam footage and had to wait months and months and months for it, at the time that we found out about this case. We didn't have photos of the defendant's car. We didn't have photos of blood on the roadway. We didn't know any information about it.
And you mentioned
the
a photo of blood. Sorry, y'all, but there it is.
Right. So the best thing we could do is to go there. So we hopped in a car. Me and one of our paralegals went and took photos.
Why did you bring a paralegal? Tell everybody why you brought a paralegal.
We brought a paralegal because she was a notary. And so I wanted to be able, if I had to get an affidavit from somebody there, I wanted her to be able to notarize it. One of the things we do, and I don't want to backtrack off this too much, but we have a portable printer that we actually bring places with laptops, so that in the event that anybody says, oh, well, you know, the attorney's typed this affidavit for you, this isn't your actual testimony, we can say, no, we sat there with a laptop and a portable printer, printed this affidavit off based on what they told us to, and they signed it, and our notary was right there. Yeah. So what we did is we went door to door and literally knocked like we were trying to sell pine straw. I mean, we were, hey, do you know anything about this guy? Hey, did you see the injury out in front of your house? Hey, do you know anything about this? And what we learned are a couple things. Neighbors don't always want to talk about their neighbors, but some really do. And we learned
especially bad neighbors. If you're a bad neighbor, people will talk about you.
And what we found here is that the neighbors that had children, young children, were willing to talk about this defendant because he had a history of whipping out of that driveway all the time. He was speeding through the neighborhood. And so we got an affidavit that day saying that very thing. We got another affidavit from a woman who, before we went to the site, didn't know this, right? She was in her driveway at the time that it happened. She happened to be trained in physical therapy. She happened to be trained in first aid because her daughter was a Girl Scout. And she actually went to our client, shined lights in his eyes, tested his pupils, essentially did the first aid check immediately after it happened. So we got evidence from her. We took a photo of that car because it still hadn't been repaired by the time that we got there. We even found that it was kind of a rainy day, so it was hard to see it. The picture didn't turn out great, but we even found the stain even after it had been washed off by the fighters who had come to the scene and pressure washed the roadway. We actually found where the stain of his blood was still on the roadway, and it was almost a week or so after. So just emphasize the importance of, if you get these cases soon, right after it happens, the first thing you should do is drop everything and go to where it happened.
Yeah, and truthfully, I think it's borderline malpractice not to drop everything and go run and go do this, because what's the rule in our office, Stokes, about new cases and old cases?
New cases are more important than old cases.
That's said with a little sarcasm there. I can sense that. But in truth, and I tell clients this, we're not shy about it. If your case is new, if it's brand new or there's a new development, that is more important than an old case. I can push something back that doesn't need to be done today. But if I have a new case, I need to go and get what Stokes did. Hop in the car immediately, go door to door, get photos. I mean, I'm sure he stayed completely on the public sidewalk when he took the photo of the defendant's car. I'm sure he did. But you got to be there. You got to go up and do whatever you can do. I mean, and if you can't do that, I'll tell you, if you can't do that, you shouldn't take the case. If you can't do that, you should find somebody else who should or who can, or you got to hire somebody to go do it immediately if you can't do it. So the pre-suit investigation here was from day one, and we got evidence that we never would have gotten, and we got it so quickly. I mean, the affidavits from neighbors talking crap about the guy as a general driver, maybe that never comes in unless we can show a habit or a reputation. But heck, that's pretty good to put in a demand. And then we have the lady who's the eyewitness, and we knew about her before the police report came out, I think. I mean, police report wasn't even ready. So if you caught, I think last week's webinar on bad faith, I mentioned something called a skinny demand and a full demand. Our skinny demand is something that's really short. I'm going to show you an example of one later with Chris Jackson here. Next session here, next little case that we're going to talk about. Stokes, did you do a skinny demand in this case?
I did not.
All right, let me show everybody. So for if you're a numbers person, our client ended up having a brain injury, and brain injuries are the hardest cases to value because you got to really prove the brain injury. And our client could walk in somewhere and you wouldn't know he wasn't okay until you started talking to him. But he had 200 and something, 276, 267 in medicals. And that was about it. I mean, maybe it would go and touch 300, but he wasn't going to need anything else substantial. And then I remember I was on vacation when I got the call. There was an umbrella policy for the at-fault driver. He was actually driving his mom's car. So Stokes, what were the total limits?
So the at-fault driver, because he was living with his mom and still had car insurance through her at her home, was $500,000 for the car insurance with $1 million umbrella policy on top of that. And our clients had $100,000 in UN on top of that.
So we're at 1.6 combined. So when we have 2 and change in medical bills and we have a brain injury. So, this to us, and you can tell me I'm wrong, please tell me I'm wrong. I didn't think that this was a guaranteed 1.5, 1.6 case.
No.
I mean, I just, based on what we knew, I didn't think it. I thought it was very fair, but I didn't think it was guaranteed by any stretch.
Right. And one of the things we did, and this is a case-by-case basis whether you really want to do this, and it could have backfired, but we felt comfortable that our case was good enough and that our client's injuries were so bad that we could rise to the standard. We kept an open dialogue with this adjuster from the start of the case until through the time we sent the demand. And one of the things that this adjuster said was, in traumatic brain injury cases, we like to see neuropsychology evaluations.
I forgot about that.
And I rolled my eyes because we don't like those because they don't always show the best picture of whether someone's injured. And the result is usually someone has a mild traumatic brain injury.
Which by mild doesn't exist on brain injuries. Every brain injury is traumatic. That's nonsense.
Right. So it kind of takes the word traumatic out of play.
Yeah.
But with brain injuries and how you evaluate them, there's a 6-month period and a 12-month period. We wanted to get our demand out after this 6-month period. because our client wasn't able to work anymore. We wanted to take a crack at it sooner rather than later. And so we said, you know what, go get the neuropsychology evaluation. And it came back saying, yes, he had a mild traumatic brain injury, but it came back stating that he had a whole slew of symptoms that demonstrated that it wasn't exactly mild. So then when we go to this demand, and I've got a conversation that's been ongoing with the adjuster for months on this case, I can say, you asked me to go get a neuropsychology evaluation. We got it, and look what it says. And it says he has complications with X, Y, and Z.
And I remember listening to you on the phone. I mean, the story that, and I don't mean story in a bad way. I mean, the narrative the message that we kept sending in every conversation was, this is a policy limits case. And we kept repeating that over and over and over every time we talked to the guy, you know, hey, what do you need? Because this is a policy limits case. Oh, we're going to make sure we get our demand. You know, he wanted a demand a month earlier or something. And we said, we're waiting on these last records. We want them so we can send you a true bad faith demand and, you know, and hold your feet to the fire. So we're sending that message every single time we talk to him. I mentioned the skinny versus full. Stokes' demand here is 36 pages. And I'm just going to skim through to give you all an idea of what we have. This is the liability section. Here's the medical treatment. Did we use a nurse on this case, or was this all you?
I don't recall. I think we may have used a nurse just because there was so much medicine with the traumatic brain injury.
So starting here, we start with the medical treatment. And again, this is demand. We want to get paid. We're selling to them. So Stokes and most likely a nurse put this together. And I mean, here is really a true step-by-step. We're including screenshots. That way the insurance company doesn't have to go look through, in this case, thousands of pages of records. It's right in front of them. It makes their life a little easier. And I mean, we have a substantial, this is all meds. This is all medicals. We get to the medical bills, and then we have pain and suffering. We also included loss consortium just to ramp it up. We ended up not needing it. We went through the driver's history, even though that's probably not going to come in. What's the harm in saying it if you know it? And here's something that I think was interesting or important that we did. Here's our demand, this section. I think this is actually Ben Broadhead. Nope, it's Matt Stoddard. It says it right now. I wish Stoddard was here so I could give him a shout out to his face. But I remember we used case metrics on this case to look at some jury research, and I remember not liking the results. There weren't some great results for us that we thought matched our case. And that was good to know, because we then were able to go and we looked at the daily report. And I think this article had just come out, right, Stokes?
This came out a week or so before we sent our demand. And so we had just actually talked with Matt about this case because he had presented something about it, and the stars kind of aligned that said, okay, this is a perfect example of a similar venue, a traumatic brain injury that didn't have a skull fracture or bleeding that we had. It was just simply a traumatic brain injury. And so to see what a jury would do for a sophisticated person with a high salary that, a lot of the component of this, or a major component of that verdict, was lost wages. We thought, hey, let's use this to illustrate what happens in our case 2 years from now.
Yeah. And then the last thing we do here is, starting this paragraph right here, should farmers insurance, should farmers not accept the demand, here's what's going to happen. We are going to go and get an excess verdict, and you made these promises. We found this on their own website, and it explains what the heck an umbrella insurance is. And crazy enough, I mean, it says your son causes an accident is their example. The chance of that is, but because this is obviously the woman's son caused the crash. But the whole idea here of what they're saying is, from their own website, is an umbrella policy is here to protect you. And now we're saying to them, you got to live up to your word and you got to protect them. So we're writing this section. I've talked about this before in some other webinars. We're writing this section essentially on behalf of the insured, the at-fault driver, to their insurance company, saying, protect these insured, protect your insureds by paying the money that protects them, that gets us what we want. And if you don't, you're going to look really bad, because we're going to show your own damn website to you, and you're going to look stupid in the bad faith trial. And then Stokes, once we got paid on the 1.5, it was actually surprisingly easy to get the 100, which I know you were surprised by and I was too.
Yeah, I can't remember who his uninsured motorist coverage carrier was, but a lot of times what we see in these really large cases where a substantial amount has already been recovered and the amount above that is minuscule in comparison is that uninsured motorist coverages do what they're supposed to do. And so we've had that happen in at least 3 or 4 cases that I can think of where the was just nothing in comparison to the underlying insurance policy. And they stepped up and did the right thing. And we had good opposing counsel on that one. A lawyer over at Swift Curry was really understanding and wanted to get it resolved. So that was good.
I think the takeaways here is one, the pre-suit investigation, and it's way pre-suit. I mean, the investigation you do has to be done immediately, especially in a case like this where it's been days, which we don't have a look at cases that often that are days out. So if all of you refer me case, please go do this, make our job collectively easier and help us improve the value of the case. And then the second takeaway, I think, is that in a demand, if you're trying to sell it, you got to sell it. And, you have to leave no question unanswered, and you have to sell that same story every conversation you have with the other side so that they start buying in. I call it Donald Trump theory. If you say you're the greatest, every single time, well, a lot of people are going to start believing you. So if you start telling a story over and over and over, the other side's going to believe it's true, even if you're not sure. And here our story was, this is an excess policy case. This is an excess case.
Right. And the last thing I'll say is when the adjuster would ask about whether we had X or whether we had Y or whether we had Z, we could affirmatively say, no, look, no footage exists from somebody's Ring doorbell because I knocked on the doors and found out. This is the only information that you're going to have to evaluate this case. And you know that because we went and got it, and there's nothing that you could possibly think of that we didn't already do. So at that point, he kind of felt like it was an uphill climb, and whoever he hired as defense counsel was not going to be able to create any evidence that helped them.
All right, Stokes, good work. I'm kicking you off.
Thanks,
Say bye, everybody. See ya. All right. You're back to just me for a second here. The next case we're going to talk about is a bad faith case, a case that turned into bad faith. If you watched the webinar last week, thank you. Yeah, we're going to touch on a lot of those same topics. If you haven't, the YouTube page has the webinar from last week. It's Bad Faith, What You Need to Know. So let me call up Chris Jackson here. I wonder what his facial hair situation is. I don't know. Let's find out. Here's the moment of truth. Whoa. Whoa. All right. Looks like a human.
I know. It's the best I've looked in quite some time. Shout out to my girlfriend and YouTube videos for teaching us how to cut hair.
Did you cut your own?
Oh, I didn't. She did. Yeah.
Okay. I'm still holding tight.
It's not too bad.
Yeah. All right. I've got a timeline for this one because I think it's important. Do you want to tell everybody just the general facts and what the injuries were? It's a car crash case.
Sure. So our client late at night was traveling on DeKalb Avenue. Anyone who's familiar with that road knows that it's divided by dotted lines into 3 lanes, and that sometimes the middle lane goes one direction, sometimes it goes the other direction. I'm just mentioning that so maybe people familiarize themselves with the road, but in this case, the middle lane did not make a difference, and I'll explain why that's relevant at all. So our client was heading one direction on DeKalb Avenue, and this is near MLK Birthplace, and the at-fault driver came out from a stop sign and went all the way into that 3rd lane, which is never the correct direction for her to go, and then turned right, basically going the wrong way down the road and hitting our client. Terrible collision, awful property damage, totaled her nice car, very serious. And when the police showed up, I don't know if you want to talk about this or not, but the at-fault driver really couldn't explain why she was going in that direction. She was really kind of combative with the police. And one of the things I thought was kind of interesting about it, maybe a little odd, was the police talked to her, and then when they get back in the car, the officers were in the body cam, talks to his partner and says, I think she might be DUI. I think she may be a little tipsy. But he didn't do any field sobriety tests. He didn't talk to her about whether she'd been drinking. It was just one of those things that I'm glad that evidence existed, even if he didn't really flesh it out, get her a DUI or anything like that. And she ended up having a serious back injury and having an anterior discectomy and cervical fusion. Mike, I cannot hear you.
Oh, y'all hear me now? Sorry about that.
Yes.
So there's $25,000 in at-fault limits, right?
Yeah.
So
right.
We're sending this demand because for a lot of reasons, I'll tell you, this client of ours actually shared office space with us. She had an office in our building.
Mm-hmm.
She was so nice. We liked her. We cared about her. So we said, yeah, we'll send a quick demand for you. We're still going to do what we do. I mean, we're not going to change how we do it. So I'm going to show y'all. So I talk about the skinny demand and the full demand. This is pretty close to a skinny. I mean, we can be much skinnier, much skinnier. I'll show you a really skinny one. But here are the facts. The facts take up most of it because we really like the property damage photo and we really like the facts of the case were good for us. We total the medical bills, but there's no real extended summary of the injuries. And then, I mean, most of the demand is our actual demand in the terms. We, of course, though, still throw in, it's against Geico. We're going on their website and we're finding something that we can throw in their face later. What this should do to adjuster is start sending off these huge sirens that, oh shit, this could be a bad faith case. Oh shit, they're trying to set me up. And if you remember Austin and my conversation from last week, play checkers, don't play virtual chess, virtual 3D chess. You know, you can't set people up. You just got to let them fail if they're going to fail. So we send this demand. And Chris, let me show the timeline because that's important. You want to walk everybody through this?
Sure. So we sent it, as you see, on May the 21st, and we made it, I believe, so it was 30 days from receipt by certified mail. So we got the green card back. We calendared when we were supposed to get a response by. An adjuster from Geico called me, and this is actually the first time I'd ever spoken to this adjuster before. She calls and says, hey, we're going to tender our $25,000 in limits. She says, we accept your demand,
Let me pause you. Our demand required three things. I should have said this. It required $25,000 within 30 days. It required an affidavit of no other insurance. We always want the affidavit of no other insurance to make sure we're not settling the case and we don't know about other insurance. Because if we do and we find out later, we've got a fraud case. Third thing, you have to agree to the terms in our release. We sent a proposed release and they had to agree that the terms were appropriate and that they were okay with them. And they had to do that within 30 days. So those three things had to be done in 30 days. Mm-hmm. So the adjuster calls Jackson on the 11th and says, we're going to pay you, right?
Yeah, she says, we're going to pay you. We accept all the terms of your demand. Oh, and hey, by the way, our legal department is still reviewing the terms of the release you sent. So
ding,
when she
ding,
said,
ding.
Yeah, so when she says, we accept your demand, but they're still reviewing, you know, the release, that's an oxymoronic thing to say. That they have not accepted our demand. There's no mere acceptance there. But of course I was like, okay, thank you, and hung up the phone and didn't want to talk to her anymore after that.
What you said at the end is really important, but let's mention that again in a second. But it also wasn't an acceptance because there was no written acceptance, and that's a requirement too. Right. So in our demands, if we send a release, they have to say in the acceptance letter, or at least say in a written acceptance form, we accept the terms of your release. So you said at the end there that you get off the phone and say, thank you very much, get off the phone. Why do you do that? And why do you not talk to her again?
I don't want to give them opportunities to correct the mistake that they're making. We've got a client with a lot more medical bills than the coverage. And if they're going to make a mistake, I'm not going to lead them away. I'm not going to fix it for them, basically. Yeah.
Now, somebody who's not a lawyer and maybe doesn't do this kind of work could think that we're being jerks. And I want to disavow that right away. In a deposition, for example, I tell my clients it's not a conversation. It is a legal interview under oath where where you're not there to help anybody. You're there to help yourself. So when you're asked a question, the answer is no. You say no and you stop talking. You don't say no, but I think what you mean to ask me is this, and let me answer that question. That's not your job. Our job as lawyers is not to help the other side. So you may feel compelled to say to the other lawyer, hey, I think you haven't really accepted my demand. I think you made a mistake. You can think that's mean to not do that. I'm telling you it's not. but your obligation and your duty is to your client. So it is, you must put your client first. And when you know that they are screwing up, it's in your client's interest for you to hang up the phone and not answer the call again. I'll tell you right now, we have a case where demand has not been made or demand has not been accepted in time. And the lawyer called yesterday. We will not call them back. If we do, it'll be at 10 o'clock at night. I know they're not in the office, but it's in my client's interest to not respond. So that's your cover. If you have a moral dilemma here, that's your cover. All right. So Jackson, June 11th, she calls you within the time period and says, we're going to accept. And then the 17th and the 18th, they send the affidavit and the check. So
Right.
What happens on the 24th? Have they done everything?
No. And what we ended up finding out, or what you found out during kind of an investigation of what was going internally at Geico, was their legal department actually didn't even approve the release until June 25th. And they didn't let us know that until June 28th. And even then, they didn't let us know in writing.
Right.
They were calling. So they messed it up a few different ways.
Yeah. So after the 24th, I called over to Geico and said, hey, I'm trying to figure out what's going on. And they told me, oh, well, we were still approving the release. And I thought what was important right here is that Geico had already, this is the same release we use all the time. So Geico had already accepted this release in however many other cases we've had with them.
Right.
And we thought that made a really compelling bad faith case, because if their crutch was going to be, we needed more time to review the release, we can eviscerate that pretty quickly by saying, you've reviewed it, I don't know the number, however many times, and you've always okayed it. So Jackson here realizes that the deadline is passed, bad faith seems to have attached, and then we need to send a bad faith demand.
Right.
Jackson, what I want to do is I want to highlight the differences between the bad faith, the sections that we added. So
Okay.
You briefly saw the first demand. Here is the bad faith demand, and what you'll see from the first few pages here is it's the same damn demand. It's the same thing. Here's where it changes, though. And you can just tell by the headings here. We're going to give basically a facts section of the bad faith. Here's how you screwed up. It was easy for us to put together the timeline that I just showed you because we gave it to them in the demand.
Mm-hmm.
So we include the demand. We include this timeline explaining exactly how they messed up. And then here's our bad faith paragraph right here where we're explaining to them, this is what it actually means. And we're writing this to the bad faith jury. We're not writing this to anybody else.
Right.
And miraculously, honestly, we just got paid on this demand. No negotiation, no nothing. We got paid.
Yeah, there was a second defense firm, and we had no idea they had anything to do with the case until they sent us a check.
Yeah. So I think the takeaways here are, one, you have to craft, and I've talked about this before, you have to craft the demand with terms that are very clear. Play checkers, not 3D chess. The second thing is, and Jackson can tell you firsthand, you need to go point by point through your demand and make sure it actually is accepted.
Yeah, exactly. It feels at first, I don't know, almost like too simple for a lawyer to do. Did they do A plus B, C? But it's a really important thing for you to do. And, I think one of the important things to also remember is that if they send you a check, you need to have some sort of system in place so that it's not reflexively deposited by whomever receives the check. Yeah, because there's some law on it. You could get into an argument either way about whether or not it's acceptance of their counteroffer, which they had made basically at that point, or at least not met our demand and gave us $25,000. But there is some law out there that would say, okay, well, you're by depositing it, you're accepting whatever their counteroffer is, or you're waiving whatever bad faith, whatever it is. Just don't do it. Just don't deposit the check. So you should probably have some sort of system in place at your office where a lawyer has gone through and made sure that they've met every single term completely before you do something like that.
Yeah, our system is really high tech. We have two folders.
Right.
One folder says cash these checks. The other folder says, or deposit these checks. The other folder says, do not deposit those checks.
Mm-hmm.
And that's a decision that in my office I make. But usually it's fairly obvious. But again, that's a really, really good point. Don't have somebody who's just cashing checks no matter what, because that's not going to work. We're getting a couple of questions about how much the case settled for. It was $450 So we sent a demand for 450, which we thought was an aggressive amount. Our client was wanting to get it done. She was self-employed and needed to get the case done. So we thought we made an aggressive number at 450. And then she had which I don't remember what it was, 150 or something like that. So we got the after that too.
Right.
So it was either a 500,000 or a 550 total recovery. Just because you settled for above the policy limits in the first, the policy limits of the at-fault driver, that doesn't mean that you still can't get So we were able to get that too with another demand.
Yeah, very happy client. I mean, we got more than we would have expected in a case like that, and I think a lot of it was just a matter of making sure that we're not playing 4D chess or anything like that. We're just playing checkers with them, and then just holding them to the standards that we create in our demands. And this way, they messed it up a few different times. And like you said, I mean, there was not much discussion after we sent that demand. It was pretty clear that they were in bad faith. They've rejected in bad faith.
Yeah, and I mean, you got to give them a fair chance to fail, and insurance companies, like everyone else, will make mistakes. So just give them the chance. We asked how quick the bad faith demand was accepted. It was accepted within 30 days of when we sent it.
Yeah, I think it was the day before whatever the deadline was.
So this whole case was wrapped up. I mean, we got the bad faith demand out pretty quick. So from the time we sent the first demand, we gave them 30 days. They fail. We send a bad faith demand. We give them 30 days. They pay. That whole time period is under 90 days. I mean, well under 90 days.
Right.
All right, Jackson, good work. Thanks for sharing with everybody. I appreciate it.
All right. Yep. Good to see you.
How do I get you out of here? No offense. There you go. All right. So the last case that I want to talk to you about, and I'm going to make this pretty quick here to be respectful of your time. The last case I want to talk to you about is a case that involves finding money and then getting it, which is what all these cases involve. But here it's a little different. So the story here is, I'm going to show you some notes. That way you can follow along. Our client is driving on I-20 and a truck swerves into a lane, which, depending on who you ask, causes either our client to move over to the side of the road and change lanes and hit somebody else, or it was reversed. The truck causes another car to go into our client and hit her. It's not a bad crash. I mean, it's not. There's nobody injured from that crash, but these three people pull over to the side of the road. The truck, the two cars, they're over on the side of the road on I-20. Call the police. Police officer comes. Police officer says to our client, hey, will you walk back to your car, get your registration, your driver's license, whatever you got? She says yes. It has been about 20 minutes from the first crash until when she's walking to her car. She gets to her car and she gets what she needs and she turns around. She's walking with traffic towards the police officer. There is another car, a fourth car, driving on I-20. That driver either loses control of the vehicle and dies in the crash that would happen, or he's driving down the road and dies, which causes him to crash. We don't know which. That driver, dead or alive, hits our client as she's walking. So this is a car on a pedestrian on the side of the road, and she's hit at highway speeds. I mean, she's flung over the car. Y'all can imagine the injury. She broke both her legs, a host of other things. So who can we blame? Who can we blame? We can blame the truck and the truck company for causing the initial chain of reaction, the initial crash that led to her injuries. It's the but-for test. But for the first crash, she would not have been injured. Now, of course, that has some limits, especially in terms of time. And we thought that 20 minutes was borderline, was borderline. We could blame the dead guy. We might have a problem though, because if he died while driving, that's probably, I mean, do you really blame somebody for that? I don't know. It's not his fault. So, but we could blame him. And we could also blame the car involved in the first crash, meaning the car who either swerved into our client because of the truck or our client swerved into. There were two different stories, so we didn't know. Figuring out all these options was important because of insurance. You want to make sure you find all of the pots of money. And second, because of venue. Because of venue. This truck driver and trucking company were out of state. They were California folks. The dead guy was a Florida driver. That other car that was involved in the first crash that either swerved or got swerved into, he was the only Georgia defendant. We decided to sue him mainly for venue. And it got us to DeKalb County. Now we know, though, we pretty much know at the end of the case, or at some point before the end of the case, that other driver might win on summary judgment if the facts end up being discovered that there was one cohesive story and it was our client swerving into him. We just didn't know. So there's a few things you can do in this situation to preserve venue. One thing is you can enter into a consent judgment against your resident defendant, against the Georgia defendant. A consent judgment keeps venue. There's these rules, and I'm not going to get into them. There's some case law about making sure that it's not purely for the purpose of venue. So you can't settle it for $1 and say, yeah, this was settlement for $1 when really you're just paying for venue. That wasn't an option here because the other driver wouldn't agree. So what we did was we sued him along with the truck company, and the dead guy. And then there's this rule right here. It's 28 USC 1446 C1. That's the removal statute, the federal court removal statute. What it says is if you keep the case in state court for more than 1 year after you file it, you can't remove even if diversity goes away. Let me say that again. The case can only be removed within the first year, no matter what. That's the simplest way to say it. So in our case, if the Georgia defendant later gets dismissed, that's okay so long as it's been a year. So what we did in this case was we delayed. We delayed, reasonably so, to serve the people in California. We asked their lawyer, will you accept service? He said, I'll get back to you. A month goes by. We've already filed. So a month goes by and he goes, I'm still trying to figure it out. Usually I'd be up his butt saying, come on, come on, come on. Now I'm saying, okay, just let us know. So, I mean, people didn't even get served for months, but the clock is still running. And then we didn't want to get through discovery because I didn't want a motion for summary judgment from that driver who probably didn't do anything wrong, or at least maybe didn't, depending on the story you believe. So what we did was we extended discovery. And a year goes by, and now I've got federal court out of the picture, and I'm going to stay in state court because there's no removal. What we ended up doing with this case was we sent a $25,000 demand to the dead guy. And if y'all want to see a skinny demand, my mouse will work. This is a skinny demand. This is all fluff intro. Here are the damages. Here's our demand and our terms. So the true demand is, I don't know, 100 words. So that is a skinny demand, folks. And what it says here, it says, your client caused the crash. Here's the police report. And your client owes your $25,000 policy because look at how much our client has in medicals as of right now. And here are the records and bills. So that's a true skinny demand for y'all. Pull up my notes again. So we send that skinny demand and we get to $25,000. The dead guy, he is underinsured. He's underinsured. So our client has State Farm. Remember, State Farm writes separate policies for every vehicle. So stacks, meaning it adds on top of each other because it's not one policy covering multiple vehicles. It's 5 policies covering 5 vehicles. So our client has $500,000 in reduced by coverage. That's $475,000. We send a demand, and what we're doing is saying the dead guy caused the crash. We're being careful. We're being careful not to say anything that is untrue, that's disingenuous, or that's misleading. We're very careful about that because we know in the back of our mind we're going to blame the truck later. So we write the demand to State Farm and say, hey, this dead guy hit our client. Here's the police report from that crash. We're not giving them the police report from the first crash. Here's the police report from that crash. This case is worth more than $500,000 combined, given her injuries. pay because the dead guy's underinsured. And they did. So right off the bat, we have 500, which is really put on the dead guy. Now we're left with the other driver who we settled with him for, I don't know, a couple $1,000 just to get him out of the case. He wouldn't agree to a consent judgment, but we took his money. If you're going to offer us money, we'll take it. And then we settle with the truck for, I can't tell you, I apologize, but a confidential amount. And the reason we settled is because we thought there was a lot of risk with summary judgment. We thought there was a lot of risk for summary judgment because if the judge says, 20 minutes is too long, that the causal chain is broken, we lose. So we explored a couple of things. We explored a high-low with the trucking company based on what the judge ruled, whether summary judgment was granted or not. We couldn't get anywhere of that, couldn't get any traction. Our client was ready to settle the case. And despite how much this was Stokes and I, despite how much we wanted to try the case, because we really, really did, this was a case where we had to pull the plug and make the smart decision for the client. And when we did that, it felt really good to be able to give her, $500,000 guaranteed right up front pretty much, and then work for the trucking money, which took a considerable amount of time, but work with the trucking company to get their money. And it was a considerable result. So, this is the takeaways that I want for y'all to share with this is that you need to evaluate all of the possible parties and all the possible insurance. And a lot of times that might tie into venue. Venue is extremely important. It's extremely important. And I think that the case value here, what we're able to settle with the trucking company in DeKalb County with a plaintiff that fit the demographics with out-of-state defendants, I think that increased our value immensely compared to being in federal court where, there's a lot of reasons. I won't go through them all, but there's a lot of reasons why the jury pool is different in federal court in the Northern District than DeKalb County. So here, venue made such a big difference. All right. The very last thing I want to wrap up with y'all is first, thank you for joining. I'm so glad y'all came and listened to this. Hopefully it helped you. Second thing is have those war stories ready for people. Have them ready to tell your victories. Don't have a 15-minute story like we've had 4 times, but have a quick little story. I can summarize all these stories in 2 sentences and promote ourselves. The third thing is it's so much easier to market other people than yourself. Arthur, Chris, and Chris are phenomenal lawyers. They are hardworking. They're dedicated. I mean, y'all hear, Arthur's telling you details from a case, I'll tell you, it was 2 years ago or something. Chris Jackson's telling you about the details of his case. Stokes is jumping in a car and going the day of. So I'm lucky to have incredible lawyers at my firm. And it's so much easier for me to tell you how great they are and tell you about how great our team is. And our team is amazing, everybody. Then tell you how great I am. That's weird. It makes me feel uncomfortable. Why would you believe me? I'm talking about myself. So on a marketing standpoint, if you can sell other people, if you can sell your team, if you can sell something else besides yourself, I think that will benefit you greatly. Plus, it feels good to talk positively about other people and give praise. The very last thing I will tell you is I think the key takeaway to this entire presentation is not that we were right, look at how we did it, we're awesome. It is you can skin a cat. Don't skin cats, but you can skin a cat 10 different ways and it work. The key is, though, you need to have a purpose with everything you do. When Stokes was calling that adjuster, he was repeating the party line of this is an excess case. When Arthur was talking to the defense lawyer in the motor vehicle case, he was repeating, y'all are in trouble. This is an excess case. Same with Jackson, all of those things. So those are the approaches we took. We easily could have done things differently, and it probably would have worked out. All that I implore you to do is think what you're doing, why you're doing it, and then execute that. And if you have a good reason for what you're doing and why you're doing it, don't second guess. Don't sit there and say, I wonder what so-and-so would do in this situation. I wonder what whoever would do. You are smart, you are competent, you are capable, your clients trust you, and you're a good lawyer. So the decisions you make, as long as you've thought them out, be confident in those decisions and then push forward. Have no fear. I appreciate y'all joining me. I would love one day to hear from you during a webinar or an email or a text or a call, whatever, for you to tell me some of your war stories and tell me about some of the success you have had, because I'd love to hear how I can incorporate the lessons from your cases into our casework. I hope that our lessons from today will help you in some of your cases. And if I can ever do anything for y'all, if any of the lawyers at our firm can ever do anything for y'all, reach out to us anytime. We are here to help. I'll talk war stories forever. If we can do it with a cigar and a drink, that's even better. So I appreciate y'all joining, and thank you. Thank you so much.